Hello, everyone. Thank you for joining us today. We are just coming up on noon, and we are very excited to have this presentation today on the intersection of human trafficking and housing law. I see a number of people are joining right now, but I do want to dive in because we have a lot of great material to cover during today's webinar. My name is Heather Heiman. I am the Human Trafficking Prevention Project Manager at Maryland Volunteer Lawyer Service, and I am very excited today to be joined by my co-host, Jessica Emerson, the Director of the Human Trafficking Prevention Project at University of Baltimore School of Law. Just say hi really quick.
Hi, everybody.
And we are particularly excited, though, to feature a presentation from our guest presenter today, Karen Wabeke, who is the Senior Housing Attorney with the Homeless Persons Representation Project here in Baltimore. Karen joined HPRP in September 2011 as a housing attorney, and she came there from Toledo, Ohio, where she spent 2 years as an AmeriCorps attorney with advocates for basic legal equality, litigating housing and foreclosure cases. Karen now leads HPRP's Housing Justice Project, offering representation to tenants in Baltimore City facing eviction or termination of their housing subsidy. Karen received her JD from the University of Michigan's Law School in 2007 and a BA in History from Wesley College in 2004. So welcome, Karen. We're very excited to have you.
Thanks. I'm glad to be here.
So like I said, we have a lot of things to cover today. A few quick housekeeping notes before we jump in. A PDF of the webinar should be available to everyone in the materials section. You can download that or print it out later. And of course, we always follow up by sending out a PDF and a tip sheet. So we try to summarize so you don't have to too frantically take notes and instead can just enjoy the presentation and ask questions. This is going to be the last presentation in our intersectionality series, which the Human Trafficking Prevention Project has been doing for the last 2 years. It is not the end of our webinars, though, our quarterly webinars. We will be continuing our webinars starting later in the fall. And we're shifting, though, the focus a little bit to resiliency and to how to best support survivors, looking at the intersection of human trafficking and continued various issues such as substance use, how to best advocate at a systems level for trafficking survivors. And so we look forward to continuing to engage with you through this webinar series, just in a little bit different format going forward. All right, so let's dive in with our agenda. So we've broken this presentation into a number of parts. We'll first be looking at the housing needs of trafficking survivors, trying to give an overview, particularly for those of you that might not be working with trafficking survivors day to day in your practice or in your advocacy work, just to give you kind of lay a foundation for a better understanding of some of the challenges that survivors can face. Then we'll be turning to housing options and eligibility requirements, looking at what we can actually do as attorneys and advocates to support survivors, particularly with things like landlord-tenant conflicts and other legal challenges that may arise. And then I'm really excited about this closing section, particularly given the continued health pandemic. We are going to be looking at the impact of COVID-19 on housing options and homelessness. And while Jess and I will be setting the stage in this first section, we'll then be handing it off to Karen to share her incredible expertise with you throughout the subsequent 3 sections. All right, so first diving into the housing needs of trafficking survivors. Oh, and one additional thing, those of you that have joined us before know this, but we do try to make space and time for questions throughout the presentation. You can either enter a question into the chat or into the questions tab on your GoToWebinar dashboard. And we will be keeping an eye on that and stopping for quick breaks to see if there's any questions and give a chance for Karen to answer them, or Jess or myself at the end of each section. So we will look forward to hearing from you throughout the presentation. All right, so when we're talking about options for safe housing for survivors, I think everyone who's listening to this probably knows that survivors really do commonly face a lot of challenging when accessing both emergency and long-term housing. From a recent publication by Polaris project, they noted that emergency shelter made up an overwhelming 47%, nearly half of all of the calls made to the National Human Trafficking Hotline. This really shows the acute need that housing presents for many survivors and individuals grappling with trafficking situations. And that quote is from a recent report in 2018, the Roadmap to Systems and Industries to Prevent and Disrupt Human Trafficking, when they specifically looked at housing and homeless systems and made a bunch of recommendations. We'll be sharing some of those recommendations with you as well later in the presentation. Many anti-trafficking programs, many do have shelter options available for potential clients on an emergency basis, or short-term options. There are some that have amazing programs that are longer term and can more fully support survivors, but many do not. And often we hear that shelters are at capacity. I hope there's going to be more money flowing towards this in the future. We've been lucky to get some amazing grants here in Maryland with some of our colleague organizations, but shelter is something that's still very acutely needed for survivors. I think there's been a continued engagement and growing overlap in services for trafficking survivors and survivors of interpersonal violence, with many domestic violence shelters now opening their doors to trafficking survivors, and that's helped open up some options for housing, but this still remains a critical issue for crime survivors overall. And what we're going to be focusing on today is not the shelter aspect of this, not the emergency housing aspect of what survivors need, but more the long-term challenges that survivors may face in getting long-term, sustainable, safe housing. That is something that, once somebody's left a program, left a social service agency, left a shelter that provided them with support, it can be challenging to access and retain that safe housing. There aren't many transitional housing programs out there, and there aren't right now that many nonprofit private sector partnerships that are really tailored to supporting survivors of trafficking. We also see sometimes that different housing programs have problematic policies, and this can extend from shelters to other types of programs that are engaging with survivors, like requiring attendance at religious services, or they have different restrictions and controls that can compound the trauma and the feeling of entrapment that survivors are already grappling with and trying to overcome. And it can really re-trigger some of their trafficking experiences when they feel like they don't have control over their basic living situation. And it's just something that's an extra challenge for survivors that you might be working with. And even when survivors are able to access public housing or an apartment of their own, or down the road purchase a home, whatever it is, they often still might need continued support with housing authorities, with dealing with private landlords, and other challenges that arise. So I think, Jess, I'm going to be handing it over to you now to discuss some of the common barriers.
Do I have control of the presentation, however that gets given to me?
I will make sure that you do.
Okay. So while I'm going through this, yes, please allow me control over the presentation, since that was kind of the theme of the previous slide.
There we go.
I want to just kind of highlight the importance of what Heather mentioned around certain housing policies and shelter policies having really traumatic, bringing additional trauma to survivors. The hallmark of trauma is lacking control and experiences that overwhelm your capacity to cope. And unfortunately, when service kind of reproduces that lack of control, that can make survivors feel like, well, why did I leave this when I'm just now having my life controlled by someone who thinks that they know what's best for me as well. So that really is something that's key and that we don't talk about enough in the context of shelter services. So some common barriers for survivors seeking housing: lack of a work history, lack of stable employment. And because the HTPP was founded around assisting survivors with criminal records, just want to always give a nod to the fact that Having a criminal record impacts your ability to have a work history and to have stable employment. Lack of savings for first month's rent, for security deposits. It is a chunk of change to be able to move, because it's first month's rent plus usually a second full month for security deposit in most places. Lacking a credit history or having a negative credit history or consumer debt. If you have some interest in learning a little bit more about this, I think it was it two webinars ago, where we did the intersection with consumer law and consumer debt. All of our past webinars are posted on the MVLS website. So if you're interested in learning a little bit more about the intersection between trafficking and consumer law, definitely encourage you to go and take a look at that webinar. Obviously, criminal records, that's something that is, the cornerstone of the work that we do. Shelter services, unfortunately, can be dangerous. They can lack affirming policies around people's sexual orientation, gender identity, or gender presentation. And then, unfortunately, traffickers know where to go in order to target people who are unstably housed or people who are experiencing homelessness. I remember when I was doing social work in New York City, the largest provider of emergency shelter services for youth, which meant that we could usually get a bed for a survivor there. There were traffickers just chilling outside waiting, because they knew, unfortunately, that was where they could go recruit for additional victims. So that is the reality. Okay. Again, circling back to criminal records, because that's what the HTPP was founded on. So the impact of criminal records on survivors seeking housing. We went into this in much greater detail, I think, in one of our first webinars, where we talked about the collateral consequences of criminal convictions, but we're just doing a very brief overview right now, or a reminder going forward. So criminal records can impact anyone from both obtaining and retaining housing. But again, we want you to kind of consider this through the lens of working with a survivor of trafficking who has a criminal record stemming from acts that they were forced to commit by their traffickers. So kind of the general overview is that the federal government sets housing policy, and then local housing authorities then interpret that. So public housing authorities, owners of federally assisted public housing, and private landlords have broad discretion to set their own screening. And, we kind of picked out some of the wacky ones, but it really is, important to know that the discretion that the landlords have can be as large as just flat bans on individuals and their family members, anyone with a criminal record, a 99-year look-back policy on anyone who is looking to live in the housing. And then it's worth noting that there's no appeal process for refusal of tenancy, because you don't have anything anymore. You're not having something taken away from you. You're just not being given access to something. So there's no appeal process. You just have to keep going to the next place. Oops, there we go. And then, like I mentioned, not just obtaining housing, but retaining housing. And sure, Karen, if you have any color commentary here, I know we'd love to hear it. But just a quick overview, there's something called the one-strike eviction policy. And this was created by the Anti-Drug Abuse Act of 1988, and then strengthened by a 1996 executive order. In our previous webinar, we talked about how a lot, or actually almost all of the challenges that folks have with criminal records and obtaining access to survival needs, one of which is indeed housing, stem from the war on drugs, and kind of the bizarre assertion that if we don't allow people to obtain housing or benefits or survive in any way, shape, or form, that's going to get them off drugs. So I think that most of us can agree that that was a little bit of a mismatch going from the war on drugs. So the general rule is that tenants may be evicted from public housing for the criminal activity of a household member, a guest, or a person who is deemed to be under the tenant's control. So that's pretty much most people. And that criminal activity, it doesn't matter if it occurred on or off the premises. It doesn't matter if the tenant was aware of the activity, or even if the alleged activity resulted in a conviction. There's broad discretion around that as well. And so this was upheld in 2002 by the Supreme Court, saying that this was perfectly, this is perfectly good law, and it remains so. And the case kind of boiled down simply was an elderly woman in public housing who had someone come in to assist her who had cocaine on his person. And she was then evicted for that. And again, Supreme Court said that that was good law. So having a criminal record, there are incredible challenges, both obtaining and retaining housing. So before we go into talking more specifically through Karen about housing options and eligibility requirements, Heather, are there, and I don't see anything in the chat, but I can't see the questions.
Yeah, I don't see anything as
Okay.
well. I think some people one person was asking about getting some audio. There should be an option to either join via your computer's audio or join via a call-in number. So I'd encourage you to try both of those. It should be available on your dashboard.
All right, now I am going to mute myself and I am going to turn it over to Karen. So Karen, thanks so much again for being here and for sharing your the depth and breadth of your expertise.
Thank you. Thanks again. A pleasure to be here. So in this first section, we're going to talk about the availability of different types of housing and eligibility criteria. So first up is public housing. And oftentimes we hear about confusion between public housing and Section 8 and what's the difference. So public housing was established to provide decent and safe rental housing for eligible low-income families and individuals. And public housing can look very different. It comes in all shapes and sizes, from maybe a scattered site single-family home all the way up to a high-rise apartment building. And we have a pretty broad spectrum of public housing here in Baltimore City. So residents who live in public housing pay rent based on their monthly income and certain expenses, such as childcare. And generally speaking, rent is approximately 30% of that resident's monthly adjusted household income. And the U.S. Department of Housing and Urban Development, or HUD, administers federal aid to local public housing authorities, who then in turn manage the public housing. So here in Baltimore City, our housing authority is the Housing Authority of Baltimore City, or HABC. The general eligibility requirements or criteria for public housing are listed here. So it is limited to low-income families and individuals. And the Housing Authority determines an applicant's eligibility, again, based on annual gross income and income limits, whether the applicant qualifies as elderly, a person with a disability, or a family. And I do want to note here that a single person does constitute a family. So it's not excluding folks who don't have children or meet one of those other categories. And then finally,
Karen,
there is, yeah.
Karen, just a quick question. I'm sorry. Is someone, and this is just a question of curiosity because I do not know the answer, are single people at a disadvantage in any way? I mean, do they rank lower on a wait list, or are they considered, the equivalent of a person who's elderly, a person with a disability, or a family?
Yeah, so there's no, single folks are not at a disadvantage. There are some buildings, some public housing buildings here in Baltimore City, for example, that are what's called mixed population. And those are buildings designated for persons who are either elderly or folks who have a disability. So if a single person is not elderly and does not have a disability, they would not be placed in that particular building, but they are still eligible for public housing, if that makes sense.
It does, thank you.
Mm-hmm. And so last of those general eligibility criteria, they look at U.S. citizenship or eligible immigration status. And then, as Jess mentioned, the local housing authority also conducts criminal record screening for eligible applicants. And so we're going to talk about that in the presentation as well. So the big caveat with public housing is that in Baltimore City, the Housing Authority operates approximately 7,000 public housing units, and they provide affordable housing through the Rental Assistance Demonstration, or what's called RAD. You may have heard about that in the news at various points. That includes nearly 3,000 additional units. So you're looking at about 10,000 units in the city total. However, and this is the caveat, the waiting list for public housing in Baltimore City is currently closed, which means that HABC is no longer accepting new applications for public housing. And they closed the waiting list at the very end of 2019, citing over 14,000 applicants on the waiting list and an average wait time of over 5 years. And that's not uncommon from what I know of other jurisdictions as well, that you can be on there for, I mean, I've heard upwards of 10, 11, 12 years waiting to get to the top of the waiting list.
Karen, just out of curiosity, is there any efforts being made to address that? Like, is it just going to be closed indefinitely, or more public housing, options being built by the city or being included in proposals by private contractors and developers?
Yeah, I mean, I think this speaks to the need overall for more affordable housing. What we have seen over the last couple of decades is a very serious disinvestment in public housing from the on the federal level. And the Rental Assistance Demonstration, or RAD, is part of that. It's really a program for housing authorities to offload public housing units to private developers who then are, in theory, fixing the units up. And, we've got concerns about, are the folks that really need those units going to be the ones that get them after they're fixed up and brand new and shiny? So, I have not heard what the plan is or the thought is currently from the Housing Authority of Baltimore City about how long it might take them to get through the waiting list, but it's something we definitely keep an eye on because it's a huge problem that folks who need housing and who can't afford market rent, we really don't have a lot of good options right now for them, unfortunately. And then there's a note, it's a little cut off at the bottom on my screen, but I just added that the Baltimore County Office of Housing they don't have any public housing units in the county, only Section 8.
So Karen, just because I like to kind of highlight this parade of horribles or these parade of horribles. So what you're saying is that not every jurisdiction in the state of Maryland has public housing. And then those who do sometimes don't actually have public housing because they had such an enormous flood of applications that they closed the waiting lists.
Right. Yep.
Okay. So this is sounding bleak.
It is. It's very bleak. Yeah. And it's going to get worse. So hold on.
Yay.
Yeah. Good times. So in terms of what issues survivors might face in applying for public housing, the big one here is criminal record screening, as just mentioned. The Housing Authority of Baltimore City, if someone's lucky enough to be on the waiting list and they reach the top, the Housing Authority is going to run a criminal background check. And they're going to do that for all members of the applicant's household who are 14 years of age and older. And there are three, so as just mentioned, the federal government sort of sets very broad requirements for public housing and gives local housing authorities a significant amount of discretion. So on the federal level, we have three mandatory denials. So The housing authorities don't have any discretion. They have to deny an applicant who meets one of these three factors outlined. The first being any household member has been convicted of drug-related criminal activity, specifically for the production or manufacture of methamphetamine on the premises of federally assisted housing. So that's pretty narrow. I've never run into anyone that fell under that category.
So that must have shifted over the years, right? It got kind of more narrow to meth as opposed to drug-related criminal activity of any type?
Yep. So
okay.
These are just the mandatory denials. So we're going to talk about the rest of the criminal activity under discretionary denials. That's where the housing authority has the discretion to sort of set their own look-back periods and what they're looking at. So I think on the next slide, we'll get into that.
Yeah.
So the second mandatory denial is if any household member was evicted from public housing or any Section 8 program because of drug-related or other criminal activity for a 3-year period beginning on the date of eviction. And then finally, if a member of the household is subject to any registration requirement under a state sex offender registration program, they would be a mandatory denial for the term of the registration requirement. So if they're required to register for 10 years or 25 years, that would also be the period of ineligibility for public housing.
And it's, you know, it's really important for our viewership or our listeningship to know that it is not uncommon for survivors of trafficking to have been convicted of offenses that land them on the sex offender registry. So again, you know, this intersects directly with trafficking survivors.
Yeah, that's a great point.
Hold on.
Oh,
yeah, I don't know why it's
well,
so
it was
small.
hiding on me.
Sorry.
So the discretionary denials are at the bottom, not on the next slide. So this is where the local housing authorities can set their own policies. So I've listed here how the housing authority for Baltimore City handles this. They will deny any household member who they determine has engaged in drug-related criminal activity, violent criminal activity, or other criminal activity that threatens the health, safety, or peaceful enjoyment of other residents of public housing. So this is obviously a big catch-all that a lot of people, a lot of applicants run into. And the housing authority has an 18-month look-back period or denial period for misdemeanor convictions and 3 years for a felony conviction. And that's sort of measured from either the date of conviction or the person's release from incarceration, whichever is later.
So 2 questions for you on this one. Would prostitution fall under other criminal activity?
So in my experience, the housing authority would say yes. I say no, right? But
and that's why we want you as our lawyer.
Yeah. The housing authority casts a really wide net. They think things fall under the other criminal activity that threatens the health, safety, and peaceful enjoyment that clearly don't. So this is an area that's very ripe for legal challenge, for sure.
Well, if anyone has a case
and
out
I
there,
will,
you know who to contact.
Yeah, and I will say, with public housing or Section 8, any sort of federally subsidized housing, an applicant who does receive a denial notice has a right to appeal or to challenge that denial. And that's because there's some good case law that says that they do have a property interest potentially in being denied access to this benefit. And so those are cases that we at HPRP handle to assist an applicant who's been denied in challenging that, to make the legal argument that, wait, this isn't other criminal activity, or this isn't violence, or whatever the case may be. What's difficult about those cases is that the applicant has to request their hearing, or it's called an informal review. within 14 days of getting the denial notice. So it's a very short window of time. And so a lot of times we hear from people a month or two after they receive the denial, and that appeal is sort of off the table at that point. So
and I would
just
say that's probably likely purposefully so.
Yeah, well, and you think about really vulnerable people who need public housing they may be experiencing homelessness. They may not have a stable address to get mail at, you know, I mean, they're challenge upon challenge for sure, with folks being able to exercise those appeal rights. Yeah.
Right. And my only last question about the 18th month and the 3 years. So if I am just out of jail and I manage to get myself on the waiting list, I can hedge, you know, I'm going to hedge my bets that it's going to be more than 3 years. And then okay, so I'm not allowed on the waiting list if I'm in this waiting period here, or I'm in this discretionary denial period, but
correct.
Obviously, okay, gotcha.
Yeah, and we advise, back before the waiting list closed last December, we advised people, apply now. You know, it's going to be 5, 6, 7 years. You know, maybe you won't need the public housing at that point, but better to have the option and not need it than the reverse. So if the waiting list does get back opened up, we always encourage people to apply. If you don't need it when you get to the top of the waiting list, you can just say no, and you can sort of that 18 months or that 3-year look back period can run concurrently during the time that you're on the waiting list.
Great. Thanks, Karen.
All right, so switching now over to Section 8. This is called the Housing Choice Voucher Program. Most folks know it as Section 8. And so those are used sort of interchangeably. And this is the major program for assisting low-income families and individuals on the private rental market. So because housing assistance is provided on behalf of the assisted household, voucher holders or participants are able to find their own housing, including single-family homes, townhomes, and apartments. The voucher holder or participant is free to choose any housing that meets the requirements of the program. They're not limited to units located in subsidized housing projects. And again, vouchers are administered by local housing authorities. There's federal funding that flows through the housing authority to administer the voucher program. And I like to think of the Section 8 sort of relationship as a triangle. You have the housing authority, you have the landlord, and you have the voucher holder. So the housing authority pays the subsidy directly to the landlord on behalf of the voucher holder. And then the voucher holder pays the difference between the total rent and the subsidy to the landlord as their monthly rent. And again, that's roughly should be about 30% of the household income as well. So here in Baltimore City, HABC administers roughly 13,000 Section 8 vouchers, and the Baltimore County Office of Housing administers just under 5,000 Section 8 vouchers. Eligibility criteria are probably going to sound pretty similar to public housing. They look at income, family size, citizenship, and immigration status. And again, they conduct criminal record screening for eligible applicants. Unfortunately, the parade of horribles continues. The Section 8 waiting list in Baltimore City is currently closed. It was closed back in 2014. They actually did a lottery, and they took applications for a 9-day period, and they received nearly 75,000 applications. And then they did a lottery and selected 25,000 lucky applicants who got on the waiting list. Not that they got a voucher, they just were lucky enough to get on the waiting list.
And how long is the
the
wait
Section
for Section 8 compared to, our 5 to 11-year waiting period for public housing?
Yeah. So what we know is that the turnover rate of vouchers in Baltimore City is somewhere around 1,000 a year. So you have 25,000
Wow.
folks on the waiting list. So yeah, 25
Gotcha.
years. I think at some point they will maybe do another lottery. They don't want the list to get too old, too stale. But I mean, people die while they're on the waiting list, waiting for housing. That's just the reality of the situation. And the Section 8 waiting list in Baltimore County is also closed until further notice. As with public housing, voucher holders, survivors who have a voucher may face some issues with criminal record screening. The Housing Authority of Baltimore City, again, looks at every household member who's 14 years of age or older. And I think we have the same mandatory denials here: the production or manufacture of methamphetamine on the premises of federally assisted housing, and anyone who's required to register as a sex offender. And then we have the same much broader discretionary denial here locally for drug-related, violent, or other serious criminal activity, 18-month look back for misdemeanors, and 3-year look back for felonies.
Before we go to the next slide.
Oh, go ahead.
I just wanted to know if there was a question. So maybe we could go back to the prior slide. So it was related to, and it's a little bit, I think it's a little bit, that's okay. The question was regarding what criminal activity can land survivors of trafficking, basically on the sex offender registry list, and why are they placed on that list if the actions they engaging in were via force, fraud, or coercion? It's a rather nuanced question, and it may be kind of case-specific answers. But Jess, I don't know if you've had have any like anecdotal situations you could share where you've experienced someone, had a client who experienced getting put on the sex offender registry, or if we see that commonly in Maryland.
So our client base who experience this primarily are charged on the federal level, and they are charged as traffickers along with their trafficker. Typically because they have, I mean, this is a long, I don't want to make this a long answer, but because of their actions, they were perceived by prosecutors to have crossed the line from victim to victimizer. Now, I would argue that that is a distinction without a whatever that phrase is, and that people who kind of ascend into quote unquote leadership positions within a trafficking survivors criminal network are indeed doing so to keep themselves alive, and oftentimes to keep newer victims alive. And so a lot of our clients that have criminal records that stem from that kind of a scenario, they're charged with trafficking, they're charged with conspiracy to commit trafficking of it's always of minors, or they're charged with Mann Act violations. And they are placed on the sex offender registry just like their traffickers. And the question about, well, why would they have that conviction if the actions that they took were as a result of force, fraud, or coercion? Dear listener, your guess is as good as mine, because I completely and totally agree with you. And so what we do through the human trafficking prevention projects, we're not prosecutors, we're definitely not involved in the federal world, is that we will advocate in active cases, and we will take these cases on after the fact to try to either get a pardon, to try to get a presidential pardon, which is apparently impossible unless you know certain celebrities. Yes, there's no federal
vacatur relief, so that's really, the options are limited.
They're really non-existent, to be quite honest with you. There is a sustained, I mean, before COVID, was a sustained push for the last 4 years to try to get a criminal record relief statute on the federal level, but it's been challenging. I mean, there's movement, and I think we were heading in a good direction, but then COVID hit. And so I have no doubt that that fight will continue in the future, but I agree with you. I don't know why they would be convicted for a trafficking offense when they were victims of trafficking themselves.
And a shout out to the National Survivor Network for doing incredible work on that push. So.
Exactly. Before we go into renting from a private landlord, Karen, can you just say a few words about source of income discrimination and the work that's been done in Baltimore City to end that practice?
Yeah. So for the last decade plus, there has been an effort on the state level and then also in local jurisdictions to get a law passed that would prohibit landlords from discriminating against tenants based solely on their source of income. And it applies to all sources of income, but including, for example, alimony or other things, but how it most often comes up is with Section 8 vouchers. So previously it was lawful for a landlord to refuse in Maryland and in Baltimore City to rent to a voucher holder. Thankfully, that is changing. It took a really long time and a large coalition that HPRP was part of to get it done. But in Baltimore City, the law takes effect October 1st and prohibits that discrimination. It also passed the General Assembly on the state level this year as well. So I think that is going to do a lot to help voucher holders. Yeah, because the first battle is trying to get a voucher, as we've been talking about. The second battle is trying to find someone who will rent to you when you have a voucher. So this is really important to address for voucher holders. So we're really excited.
Thank you for that. I don't know if I did this right. For the person who was asking about kind of the nuances around being charged federally as a trafficker, I authored a law review article called Left Behind, How the Absence of a Federal Vacature Law Disadvantages Survivors of Trafficking. So you might want to check that out for some baseline reading on that question.
Great, and I think that's in the chat,
yes.
the title of that. There was one additional question before we go on to the next slide, asking about how long a voucher lasts and if it needs to be renewed, once you finally are able to access one. Is there, anything that advocates should be aware of surrounding, its duration?
Yeah, so the voucher is available, should be available as long as the voucher holder needs it. The only scenario in which that might not be so is if there's some, there isn't sufficient funding made available on the federal level for the housing authorities to maintain all of their vouchers. We're not there yet, but probably not outside the realm of possibility. But in theory, no, the voucher can last for the rest of the voucher holder's life, if need be. And voucher holders do have to periodically complete a recertification. It used to be in Baltimore that was an annual thing. I believe it's now biannual, at least for some voucher holders, and that process can be challenging for folks, but they have to basically recertify as to the members of their household, household income, and the housing authority will determine if the rent needs to be adjusted or the subsidy needs to be adjusted and all of that. But otherwise, the voucher, it doesn't expire, it doesn't end after a certain period of time.
So the voucher will travel with me if I want to move?
Yes, that's the other really great feature of a Section 8 voucher, is that it comes with what we call portability. So if you're living in Baltimore and you have family in Ohio like I do, and you decide that you want to move to Ohio, you can go through the process to port your voucher to another jurisdiction and still receive the subsidy with the voucher anywhere in the United States.
Oh, wow, even out of state. I knew it was portable from, you know, Baltimore City to Harford County. I didn't know it was portable from one state to another.
Yep, it is. It's another really difficult process.
I'm sure.
So, you know, huge pitfalls, lots of ways it goes terribly wrong. So just give us a call if you encounter someone who's trying to port. Okay, so last but not least, renting from a private landlord. In private housing, unfortunately, there are no anti-discrimination protections based on someone's trafficking survivor status alone. However, if a survivor is applying for housing through a program that's subsidized by HUD, the Violence Against Women Act may apply and provide some protections if the survivor can demonstrate that they are also a survivor of domestic violence, sexual assault, or stalking.
So I have to have experienced more than trafficking. Excellent to know.
Yeah. It's bleak. Yeah, and then last point, otherwise the landlord has even more ability to refuse to rent to someone than a housing authority does. They also are going to look for a criminal record and can sort of set their own criteria for that, and they look at credit as well. Briefly wanted to touch on housing discrimination on the federal, state, and local level. So on the federal level, the Fair Housing Act prohibits discrimination in the sale, rental, and financing of housing based on race, color, national origin, religion, sex, familial status, or disability. And I included some contact information if someone wishes to make a complaint to HUD under the Fair Housing Act.
And you'll see that this is going to be under every single one, and we'll make sure that's on the tip sheet.
Yes, thank you. State law also prohibits discrimination on all of the grounds listed under the federal level, and also on the basis of marital status, sexual orientation, and gender identity.
That's excellent.
And complaints can be made with the Maryland Commission on Civil Rights. And then on the local level, it covers everything that I've mentioned so far from the federal and state level, but also prohibits housing discrimination on the basis of age, ancestry, and, as we talked about now, source of income. And complaints can be made to the Baltimore Community Relations Commission. In addition to filing an administrative complaint with HUD or MCCR or the Community Relations Commission in Baltimore, individuals who believe that they've been discriminated against with respect to housing can also pursue enforcement by way of a civil lawsuit. So there are options, and they should talk to an attorney to get more individualized advice on that. Okay, and here we have some potential inclusions for lease agreements from that same Polaris project report. Protecting survivors from housing discrimination, eviction, or other punishment based on their status or history as a victim of crime. Protecting survivors' right to call the police for emergency assistance. We see this play out sometimes if a local jurisdiction has what's called a nuisance ordinance. Landlords can use those to push tenants out of properties, tenants who are calling the police, perhaps because of abuse or trafficking related issues, to try to push them out of a property. Allowing a victim to break a lease without penalty, where they can provide adequate documentation of their victim status. Affording victims the right to have their locks changed or other reasonable security enhancements, really important. a commitment to upholding any and all protective orders that are in place, and ensuring complete confidentiality of all housing records and documented victim status.
So how would a survivor go about getting this done? Is this something that an advocate can help with, or do they need to come to like a legal aid or something like that?
Well, I think that, they could certainly start with just having a conversation with the prospective or current landlord. It may require the tenant to disclose their status, so that's something they'll want to think through. To be honest, in my experience, landlords typically have a form lease agreement that they're going to present to every tenant, but there's no reason that an applicant or a tenant can't start that conversation and try to get some protections added to the lease, for sure. And if they run into issues, there's a number of legal services programs that may be able to provide some assistance.
And we can send out a copy of that Polaris report. It is an interesting kind of summary of some options that are available. And I also wanted to note, I realize we are getting within 10 minutes of the hour. And this is per usual. We always schedule these for an hour and usually always end up going over. So for those of you that are able to stay, I'm anticipating we won't go longer than 1:30. But if you have to leave, the webinar recording will be available on MVLS's website if you want to catch up later with anything that you had to miss. So thank you.
Okay, so switching gears a little bit, I'm going to talk about addressing landlord-tenant conflicts. And the first slide here discusses unsafe conditions. We hear a lot about conditions issues in properties from the clients we represent. So as a starting point, Maryland law does require landlords to repair and eliminate conditions that pose a serious and substantial threat to the life, health, or safety of occupants. And I listed some examples here that, at least in Baltimore City, the courts generally seem to agree for the most part that these are substantial and serious threats to life, health, and safety. And that's things like lack of electricity, lack of heat or light or water, lack of adequate sewage disposal, a rodent infestation, water intrusion, if there's water leaking in through the roof or the basement or the walls, lead paint hazards, structural defects, and fire hazards generally sort of meet that standard in Maryland. Now, the tenant must give the landlord notice of the conditions that need to be repaired and a reasonable amount of time in which to make the repairs. And if after the tenant does that, the landlord fails to make the repairs, the tenant has the right to pay their rent into an escrow account established at district court. And the court will hold the money in the escrow account until the judge hears the case and makes a decision. And so I think the idea here is that it will incentivize landlords to make repairs that need to be made so that they can get their money. And at the end of the case, a tenant, it's important that they understand up front, they may get all of their money back, they may get some of their money back, or they may get none of the money back that was paid into escrow. That is within the judge's discretion to decide what to do with the money that was paid into an escrow account. A tenant can file a complaint or rent escrow one of two ways. They can do it affirmatively, or they can raise it as a defense in a failure to pay rent case. So, if the tenant has decided, I'm not going to pay my rent because there's a huge leak in the ceiling and it's starting to fall in, they can raise that defensively in that non-payment of rent case, but they also don't have to wait to raise it in that context. They can go down to the courthouse on their own and affirmatively file a complaint asking the court to open that escrow account and get that process started. Rent escrow is supposed to be very user-friendly, but I think that tenants can really benefit from legal representation in these cases. It can get complicated and difficult to navigate. So I've included contact information for each PRT and a couple other organizations that do rent escrow cases as well.
Great. And again, all of these resources will be on the tip sheet.
Great. Next topic is evictions. And I always like to start with making sure we're on the same page that there is no such thing as a self-help eviction in Maryland. It is illegal for a landlord to just change the locks on their own. They have to obtain a judgment for possession from a court, and they have to schedule an eviction with the sheriff's office. If a sheriff is not present for an eviction, odds are it's an illegal eviction. And we know that this happens, unfortunately, all the time. It is also illegal for a landlord to shut off gas or electric service in an effort to force the tenant to move out of the property. And we have got a couple of these cases right now where during the pandemic, when landlords couldn't get into court to evict a tenant legally, they decided to take matters into their own hands. And there are civil and criminal penalties for illegal eviction and what's called willful diminution of services in Maryland. So it's a big no-no. If you are in contact with a tenant who believes that they've been illegally evicted or their landlord is threatening to illegally evict them, they should call the police, and then they should get in touch with an attorney for further legal advice. Next point, if a tenant receives a court notice for an eviction case, that could be a failure to pay rent case, a breach of lease case, or what's called a tenant holding over case. In big bold letters, they should go to court, always go to court. If the tenant doesn't go to court, the court is automatically going to rule in favor of the landlord. So any chance that you have, any argument that you have will sort of obviously not be raised if you're not there. Tenants can represent themselves or seek legal representation, and there's a real effort right now. I practice in Baltimore City, so I'm most familiar about what's going on in Baltimore City, but there are lawyers down at the courthouse. It's not every day, almost every day, available to offer same-day representation to tenants. Tenants can also call different programs to get connected in advance, but we are here. We want to help, but the tenants really need to go to court. And
you were in court this morning because you emailed us and said, I'm just getting back in. I'm going to take a look at the PowerPoint. Yeah. So Karen is really there. Yeah. And Karen, this next slide is I think my favorite through all of the slides. And I think it's really important because whenever you're working with survivors in any kind of legal or otherwise dispute, service providers, advocates, lawyers are going to want to think about reducing trauma and triggering for survivors, because just going to court can be scary. And so I think you have a lot of good tips to share with us going forward.
Yeah, this is really important. Court's a scary place and can be really intimidating and re-traumatizing, as you said. So some thoughts and some ideas that we put down to try to reduce that. Prior to any court proceeding, students or program staff should discuss the survivor's rights in landlord-tenant court with them, help them understand how the process works, what to expect, and what their rights are. If possible, working with the survivor to obtain counsel so that a housing attorney can work with them to either mediate the dispute and come to a solution, and maybe it won't even get to court, or attending court with the survivor to advise and negotiate, or to represent the survivor at trial. If there's not time to retain counsel, because these cases can move quickly, it's always fine to ask if the housing attorney can just speak with the tenant to help them understand what to bring to court, what to do when they get there, where to go, who to talk to, who to check in with, and what they can expect. Students and program staff can also offer accompaniment to court to help connect with housing attorneys or other support staff on the day of court, just to help navigate the bureaucracy of the courthouse, and to act as a buffer between the tenant and the landlord. We've seen some crazy things in landlord-tenant court. It's the landlord-tenant relationship is extremely personal and can be very fraught, and so just having someone there to sort of help shield you or be with you, to comfort you, can be helpful. And then finally, the survivor or tenant is not required to speak with the landlord to negotiate. The court will often send the tenant and the landlord out in the hallway before they will even hear the case. They say, go in the hallway and try and work it out. And this is a way in which sometimes landlords really bully and abuse tenants, pressuring them to agree to things that they don't want to agree to. It is absolutely the tenant's right to have a trial, to have their case heard by the judge if they believe, in particular, in any circumstance, but if they think the landlord is going to attempt to use those power dynamics as a bargaining chip, maybe going out in the hallway and talking to the landlord one-on-one isn't a safe or productive thing to be doing. So they can always say no. And the court still has to hear their case.
Yeah, that's really excellent, Karen. For any of you who were able to catch our trauma training, our Trauma 101 training, we talked about the pieces of trauma-informed lawyering, one of which is transparency, one of which is predictability. And Karen really highlights, efforts that can be taken by advocates to make the process more transparent and to make sure that the survivor knows what to expect, so that it's a predictable or a more predictable experience for them. For some reason I can't, oh, there we go. Okay, whoops.
Okay.
All right,
so the last yeah, last but not least is COVID-19 and the impact on housing options and homelessness. So again, going to approach this in the framework of federal, state, and local level. So starting at the federal level, you may have heard of the CARES Act. This is a law, it was signed into law on March 27th of this year. It instituted a 120-day eviction moratorium for non-payment of rent in covered properties. So that 120-day eviction moratorium ran from March 27th through, well, it's really, depending on how you count the days and who you talk to, July 24th or July 25th. Regardless, it's over now, unfortunately. Congress has not taken action to extend it, much to our chagrin. And I won't go into the weeds on covered properties, other than to say that the CARES Act did not apply to every tenancy, to every property. There were certain types of properties that were covered. The CARES Act, in addition to the 120-day eviction moratorium, it requires landlords to give the tenant 30 days notice prior to filing for an eviction after that eviction moratorium ended. So this is something that, landlords are not necessarily doing based on what we've seen. And so it's a defense that can be raised in eviction cases if the tenant is residing in a covered property. The CARES Act also prohibited multifamily borrowers who were in mortgage forbearance, so they were getting, you know, some extra time and leeway in terms of making mortgage payments. It prohibited those folks from evicting or initiating the eviction of a tenant for non-payment of rent or other fees or charges during that period of forbearance, which seems only right. And there's also the 30-day notice requirement for those situations as well.
There's lots that seems right, but for some reason.
Yeah.
I think this most recent order is going to be very interesting for people. Karen, I think there's still a lot of confusion about exactly how this impacts renters and others in Maryland.
Yeah, so the CDC dropped a bomb on all of us on September 1st, announcing that they would be issuing an order captioned "Temporary Halt in Residential Evictions to Prevent the Further Spread of COVID-19." The order was actually published in the Federal Register on September 4th. So the protections under the CDC order are in effect from September 4th through the end of this calendar year, December 31st. Unlike the CARES Act, the CDC order does cover virtually all rental properties. I do think there's a lot of misinformation out there right now about what the CDC order does and doesn't do. You know, I've read, you know, nationwide eviction moratorium through the end of the year. Nobody gets evicted, and that's just not true. So I want to take a few minutes to walk through what the CDC order says and what's required. The CDC order prohibits landlords from evicting tenants for non-payment of rent and possibly some other things through the end of the year if the tenants have submitted a declaration of income loss or significant medical expense. So the tenant has to sign this declaration under penalty of perjury and provide the signed declaration to their landlord. And once that happens, the CDC order says that the landlord cannot take any action to remove or cause the removal of that tenant for non-payment of rent before January 1st, 2021. Now, the CDC order does not cancel the rent or stop the rent from being owed. That rent is going to continue to accrue, and it will be due after the order expires. So it's really the cynical view, which is where I'm at, is that it just kicks the can down the road a couple of months. So it does offer important protections to some tenants, but there's a real need for it to be paired with significant rental assistance. Otherwise, everyone's just going to get evicted in January and February.
Right, because then I owe 4 months worth of rent instead of 1.
Exactly.
Or 9 months worth of rent.
Yeah,
Depending on.
or 9 months worth of rent.
Yeah.
So here on this next slide, I've listed, and I should sort of footnote that there is a lot of disagreement even among housing attorneys right now about some of the details and interpretation of the CDC order. So just note that. But the CDC order explicitly allows a tenant, even if they're otherwise eligible under the CDC order, it allows them to be evicted before January for a few types of cases. And they're listed here. If the tenant's engaging in criminal activity while on the premises, if they're threatening the health or safety of other residents, damaging or posing an immediate and significant risk of damage to property, they're violating any applicable building code, health ordinance, yada, yada, or violating any other contractual obligation other than the timely payment of rent or similar housing-related payments. So we're fully expecting that landlords are going to try to exploit and use those 5, what should be narrow reasons to proceed with an eviction.
Yeah, there's a lot of other in there.
There's
That could be
a
a lot
lot
of different
other.
things.
Yeah.
Yeah, and I'm just thinking about folks who, are really struggling to make ends meet and might be, might have turned back to sex work, in their residence to try to be able to keep their heads above water. It just, there's so many intersecting challenges and vulnerabilities there that could be exploited by a landlord.
Karen, I know we've seen over at MVLS, many of the clients that we're working with are on month-to-month leases. They're not on like a term lease. And we've seen situations where landlords, when they haven't been able to pay their rent, the landlords say, it's not eviction for non-payment of rent. I'm just ending the lease, even though the underlying reason is that, non-payment of rent. And I think understanding how the courts are going to interpret this CDC order with such a wide variety of circumstances and approaches being used by landlords to try and not, have a too wide reading of this is really critical for advocates to think about.
Yeah, and I mean, personally have more tenant holding over cases on my caseload right now than I have had in the previous 9 years combined.
Wow.
Landlords have figured this out, and they, many times they're filing, they start with a failure to pay rent case, and then they can't get that heard because there's such a backlog, so then they file a tenant holding over case.
Mm-hmm.
Certainly, we think there is an argument to be made that the CDC order would prohibit an eviction in that sort of end of lease term, what we call tenant holding over scenario. So if you are working with a tenant who got a notice of non-renewal of the lease from their landlord and they think they might be covered by the CDC order, definitely, feel free to refer them or connect them with the CDC declaration. There is a form that's available online, so it's not something they have to generate themselves. They just have to sign and date it and get it to the landlord.
And doesn't HPRP right now have like a specific hotline for individuals that are interested in getting assistance with the form? Or am I remembering this correct?
So the hotline we have right now is for food stamps issues. When the pandemic first hit, that was the emergency need, was getting folks connected with food stamps. But yeah, I think that my telephone number is at the end of the presentation, and folks can just call our main line, and those calls get forwarded to us, and we'll definitely follow up.
Great.
I mean, yeah, I do want to say, the CDC order, and on this slide, I sort of list the 5 big things that the tenant would have to swear to under penalty of perjury by signing the CDC order. It is something to take seriously and really think through for a tenant about whether they can honestly and in good faith, meet all of these criteria. It's not just a form that they're signing. It's a little more serious than that. But the 5 things are
swearing under penalty of perjury. It's a pretty big deal.
Yeah.
Well, that's where I think consulting with an attorney via HPRP or other groups that are working on these issues could be really critical.
Yeah, for sure. So the 5 big things are, number 1, that the tenant is unable to pay the rent due to a loss of income or extraordinary medical expenses. Now, one difference, we're going to talk about I think in a upcoming slide, the state level, our governor's executive order on evictions. Unlike the governor's order, the CDC order, the loss of income does not have to be directly related to COVID-19. It's much more broad. It can be any substantial loss of income. Number 2, that the tenant expects to make less than $99,000 individually or twice that as a family in 2020, or they received a stimulus check, or they didn't have to file a tax return in 2019.
Oh, that's pretty broad.
Number 3, yes, it sure is. And it makes sense because this is coming from the Centers for Disease Control. This is very much a public health measure, so it should be broad. I think it should be a lot broader than it is. We shouldn't be evicting anyone in the middle of a pandemic, but there's a lot of really good, strong language in the order itself about sort of the public health motivation for doing this. Number 3, that the tenant has tried, and I think it uses the phrase used best efforts to access any government rental assistance funds that may be available. Number 4, the tenant agrees to make partial rent payments to the landlord based on what they can afford. And number 5, that if they're evicted, they would either become homeless or they would have to move into a crowded, like a doubled up living situation or some sort of substandard living situation. So
and
those
just to
are the
be
big
clear,
5 things.
This is an and. So it's 1, 2, 3, 4, and 5.
Yes. And there's actually 7 things, but the other 2 things are basically like, I understand that I still owe the rent and sort of things like that, less eligibility criteria. So again, in order to get these protections, the tenant and all adults living in the household have to submit a signed declaration to their landlord stating that they're eligible and that they're telling the truth under penalty of perjury.
So all adults living in the household. Okay.
Yep. They should do a separate declaration for each adult living in the household. We are encouraging tenants to deliver the declaration to their landlord in such a way that they can prove that they delivered it to the landlord if that ever becomes an issue. So maybe that's by email or by certified mail, whatever works. It's certainly not required, but I can just see the writing on the wall that, landlords may claim that they never got it if you just put a stamp on it and drop it in the mail. And tenants should keep a copy of the declaration and all correspondence with the landlord. And that's really important because the Maryland judiciary has taken a very narrow interpretation of the CDC order. And I don't know if I discussed this on the next slide or not.
No, it was in the notes.
Okay, perfect, thank you, yes. So what the Maryland judiciary, they issued what they call a communication on September 4th about their interpretation of this CDC order. And they are going to, even where a tenant has signed the declaration and given it to the landlord, the court is going to treat it as an affirmative defense in failure to pay rent cases. Each judge will determine the sufficiency of the evidence provided, meaning if a landlord doesn't think that the tenant actually would be homeless if they got evicted, let's say, or they think the tenant never applied to any rental assistance programs, they can raise that and the judge will hear evidence and determine whether they think the tenant was telling the truth or not, which we don't think is supported by the CDC order, that level of involvement. And the court will hear the failure to pay rent case. Even if the tenant has provided the declaration to the landlord, the court is going to determine what amount of rent they think is due and owing and make that finding, but then reserve entry of judgment until through the end of the year. And then presumably on January 1st, January 2nd, the court is just going to sign and enter judgments in all of the cases where the CDC order was raised and judgment was reserved.
Oh my goodness, so this is really just kicking down the road.
Absolutely.
I started sweating.
Yeah, it's really bad. It's doesn't make a lot of sense to us in terms of judicial economy and efficiency to be having all of these trials when everything may change before the end of the year. And the court, there's even some language in there that, the landlord has a continuing duty to inform the court of any payments that the tenant may make while the case is pending, while the judgment is reserved. And the court, I think, is feeling a lot more optimistic about the chances of landlords doing that than I am, based on my experience. So the tenant may make payments before the end of the year, and unless the landlord does the right thing and tells the court, oh, hey, no, you shouldn't enter judgment for $1,000 on January 1st because the tenant paid me $500, the court won't know, and they're just going to take the landlord sort of at their word. So really problematic. Lots of pitfalls. Yeah.
Would you have any suggestions, again, as advocates are working with, survivors or just any populations that they might be working with of clients? Is there any action the tenant can take besides just meticulous record keeping and
right. Obsessive record keeping?
I think meticulous record keeping is always good, and having a lawyer is always good.
Is always even better.
And and we can do things if the tenant does make payments. There are ways that we can communicate that to the court to ensure that a judgment is not entered in January for the wrong amount. So we're still figuring out.
Number is going to be at the top of the tip sheet.
yeah, basically.
We're going to change this to the COVID-19.
Call Karen, yeah.
Secondary. Call Karen.
Yeah.
All right. So at the state level, I know you said that that's a bit different than the federal level.
Yeah. So Governor Hogan issued an executive order on March 16th. It was extended on April 3rd. Slightly different. It prohibits Maryland courts. It restrains the court itself from ordering the eviction of any tenant who can show that their failure to pay rent or breach of lease was the result of COVID-19 because of lost or reduced employment, needing to care for a school-aged child, or because they are diagnosed with or under investigation for COVID-19. So the loss of income or reduced employment has to be a result of COVID-19, and the tenant has to provide, I think the wording is objectively verifiable documentation. So there's going to have to be some records to support that claim under the governor's executive order.
So that's a big difference between the federal piece and the state piece. It has to be COVID-19 related.
Yeah. Yep. These prohibitions are in effect until the governor lifts the state of emergency. So potentially could be longer than the CDC order, depending on when the governor lifts the state of emergency. And then last note on this is that, it's been described again as an eviction moratorium. I think that's really misleading. This is not what I think of as a moratorium. This is, again, the courts are going to treat this as an affirmative defense. So the tenant has to know about it, raise it in court, provide documentation. So I think it's more accurate to describe it as a defense.
Right. Okay, and now the local level.
Okay, and then on the city level, yes, briefly, the City Council passed and Mayor Young signed what's called the Baltimore City COVID-19 Renter Relief Act. It was signed on May 18th, but was made retroactive to March 5th of 2020. And it does two main things. It prohibits rent increases for existing tenants during the health emergency declared by the governor. So landlords may not notify existing tenants of rent increases during the emergency and for 90 days after the state of emergency is lifted. This does not apply or prohibit an increase in the rent for a new tenant. The second big thing it does is it prohibits fees for late payment or non-payment of rent during the emergency and for 90 days after expiration of the emergency. So that's a really wonderful thing for tenants if they have gotten behind, that there's not that 5% late fee for paying late. And then last note on this is the Housing Authority of Baltimore City was specifically exempted from the Act's requirements because federal law requires housing authorities to determine rent based on the resident's household income and to adjust accordingly. So if a tenant who lives in public housing or has a Section 8 voucher lost income due to COVID, they should contact the housing authority immediately to ask that their rent be readjusted based on that loss of income.
Gotcha. Whoop.
Okay.
Wait, I screwed up.
You're fine.
Wait, why is it going? It's going forward instead of backwards. Heather, can you take over? I don't know why. Wait, maybe
Sure.
Hold on, wait, no, I got it. I don't know why the thing was stuck.
There you go.
There we go.
So try to get through this quickly, but the Maryland courts were closed to the public starting March 16th until they reopened to the public on July 20th. The Maryland judiciary issued a 5-phase reopening plan. We are in phase 4 currently. Phase 4 started on August 31st, and that's when the court started hearing failure to pay rent cases. So at this point, the court is hearing all landlord, tenant, or eviction cases with the exception of jury trials. And jury trials are scheduled to resume on October 5th. And at that point, we'll be in phase 5, and the courts will be back at full operation. Baltimore City Rent Court resumed on September 1st. They are hearing far fewer cases each day. So pre-COVID, and Baltimore City Rent Court, they hear non-payment of rent cases Monday to Friday, all day, every day. The cases were capped at 1,000 cases a day pre-COVID. They're now capped at 150 cases a day. So things are moving much more slowly, which is not a bad thing for tenants. And the court started with those cases that were pending pre-COVID and pre-shutdown, and they're working their way forward. But evictions are happening in Baltimore City. We just received an update from the sheriff's office yesterday that I think something like 192 evictions happened in August in Baltimore City.
Oh.
Last section here, and I'm not going to go into this all in a lot of detail, but just wanted to provide some information and resources about different rental assistance programs that are available to tenants. In Baltimore City, they're doing it in 2 phases. Phase 1, the temporary rent support program, that application period has closed, but phase 2 is ramping up. They're not yet accepting applications, hopefully maybe by the end of this month. And the applications, once they're available, tenants can apply through their local community action center. And I've listed, what types of assistance will be available through that phase 2 here in Baltimore City.
And Karen, if you develop or have any access, so once this sounds like an amazing opportunity that I think a lot of advocates in the at least on the task force, well, not just at least at the task force, all advocates would really like to know more about this. So if there's anything that you get that kind of we can pass out to people, that would really be helpful.
Yeah. Okay, I'll get that to you. Yep. There was also a state level program. The state allocated $10 million for the so-called Maryland Assisted Housing Relief Program. This is for tenants living in properties that have state funding. Interested tenants who think they might be eligible should talk to property management, because it's actually property management that submits the application on behalf of any eligible tenants in the property. And we also heard yesterday that not all of that $10 million has been spent. So they're still accepting applications for that. In Baltimore City, we have the Eviction Prevention Office, which is on the second floor of the district court building that hears eviction cases. The tenant must have a judgment for possession entered against them by the court. And we're just recommending that folks call first to confirm that they're open. I know they're open, but to confirm what hours, find out what they need to bring with them so that they're not making an extra trip.
Really quick, Karen, we have a question with the Baltimore rent assistance programs and the Maryland ones as well. Are there any like citizenship requirements or any parameters that people should be aware of for eligibility to apply for such help?
Yeah, so if you go back one more slide to the Baltimore City sort of phase 1 and phase 2, what I can tell you is that in phase 1, there were immigration status was a criteria. We do have a verbal commitment from the Baltimore City Department of Housing and Community Development that will not be the case for phase 2.
Oh, that's great.
Excellent.
Yeah, good work.
Because yeah, there were a lot of folks that were excluded for that reason. So we wanted to make sure that was changed. And I think honestly that's related to phase 1. All of the funding was federal funding, and so the restrictions sort of came with that. They're in phase 2 patching together different funding sources, and so they've got the flexibility if someone is undocumented to pull the money from another source to cover them.
Excellent.
Great.
Last thing, supportive services for veterans and families. If there's a veteran household in need of assistance, there are 2 programs in Baltimore City, and I've put their telephone numbers down. And then if there is a household with a child under 21 who's living with them, they may be eligible for emergency assistance to families with children. That's administered by the Baltimore City Department of Social Services. So they should call there. And last but not least, legal resources. Hopefully, if nothing else, y'all are taking away from this that, we're here to help and to represent folks. HPRP is Maryland's only legal services and advocacy organization dedicated to ending and eliminating homelessness. In addition to housing, we also have attorneys who handle public benefits cases, so things like food stamps, disability, and the like, veterans benefits and discharge upgrades, and criminal records expungement.
And we make many. Oh, keep going, Jess.
Oh, no, I was just going to say HPRP, as you can hear from what Karen's saying, they are, and Karen in particular is truly on the front lines with, housing law in the state and in the city of Baltimore, and especially when it comes to all, hopefully what sounds like a good amount of relief that will be eligible for your clients in terms of housing assistance going forward. So we just really want to thank you for lending your expertise to this. This was excellent. Yeah, discouraging, but excellent.
We here at Maryland Volunteer Lawyer Service, we make so many referrals to HPRP. We do provide some housing services. In addition, we do handle landlord-tenant disputes, but we do not do eviction work. So for those, please contact HPRP first, because they'll get you the expert advice that you need. We do handle other housing issues like title and deed questions, consumer law issues around if somebody has debt resulting from unpaid rent in the past, as well as other legal services. But I think we've answered all of our questions. And yeah, this is just a moment to, again, thank Karen so much for joining us today. We will be sending out a post-webinar survey, and we'd love to hear what you, intrepid audience members that have stuck with us through an hour and a half, think about the presentation. If you have any suggestions for future webinars, we'd love to hear them. Here is Karen's information. Karen, I don't have your phone number up here. I'm sorry. We will send that out when I send an email follow-up to the entire attendance list. But you can feel free to contact Karen or Jess and myself if you have any follow-up questions or would like to make a referral, or have a client that you're working with that could use help with any of these housing issues that are, as Karen's rightly pointed out, for many people getting quite acute at this time with the health virus. So just a few quick follow-up slides from MVLS. We are still open and continuing to accept new cases through online intake and our phone intake lines. You can see those here. You can also follow us on social media. Our consumer and debt prevention team has been doing an excellent job of trying to keep our Facebook page and our website updated with all kinds of information on new developments like the CDC order and other things that might be affecting individuals here in Maryland that are struggling with legal issues, with housing issues, with debt and other matters. If you are a MVLS volunteer and you're looking for pro bono cases, you can always go check out our pro bono portal. We are still getting a lot of inquiries for help right now, and we only anticipate that increasing as the courts move to this final stage of full reopening. The pro bono portal has case descriptions. You can easily click on to request to volunteer for a specific matter. We have a number of upcoming trainings I just wanted to highlight. Our Tax Tuesday training on October 13th for best practices for representing a non-filer. And then on October 15th, we'll be doing a legislative roundup talking about changes that happened in Maryland law this year. And I will be talking about, of course, the change that happened with the passage of the expanded vacature law here in Maryland, amongst other updates. So you can also access all of these trainings from MVLS on our recorded trainings page on the MVLS website. We have a whole host of things. If you have some downtime here, you're working from home, you need a break and want to engage in an intellectually stimulating presentation about all sorts of cutting edge legal issues, please check these out. And if you aren't yet a volunteer, we encourage you to sign up today. Thank you so much, everyone.
Thank you.
Thank you.
Yeah, and a huge thanks to Karen. Your expertise was just invaluable during this entire presentation, and we look forward to working with you continuing in the future. Thank you.
Take care, everyone. Thanks.
Bye-bye.
Bye-bye.